Clarence Thomas. God, this guy is awesome. All right. Now, this is an article I found. This is a little old. This is from last year, from August. But it's important. Excuse me. No, this one's from April. All right, but I have... It's referring to something that happened last year. Justice Thomas argues for making Facebook, Twitter, and Google utilities. Okay? Let's check this out. Last fall, Clarence Thomas argued that it was time to rein in Section 230 immunity. Now, Justice Thomas is laying out an argument for why companies like Facebook, Twitter, and Google should be regulated as utilities. On Monday, the Supreme Court vacated a lower court ruling in finding that President Trump had acted unconstitutionally by blocking people on Twitter. That case, which the justices deemed moot, hinged on the idea that @RealDonaldTrump account was a public forum run by the President of the United States, and therefore was constitutionally prohibited from stifling private speech. In his concurrence, Justice Thomas agrees with the decision, but argues that, in fact, Twitter's recent ban of @RealDonaldTrump account suggests that its platforms themselves, not the government officials on them, that hold all the power. He's absolutely correct. If they see in this right here, they're deeming the fact that he's not allowed to block someone because it's a public forum. You're the president, so everything underneath has to be allowed, has to go, you know? And the fact that Twitter banned him is basically going against this rule. So they're banning the public forum, which is the president of the United States. Look, he was president when they banned him, okay? Sure, he's not president now, but he was when they banned him, and that's an issue. It proves that the platforms themselves have all the power. He's right. This is a quote from him. As Twitter made clear, the right to cut off speech lies most powerfully in the hands of private digital platforms, Thomas writes. The extent to which that power matters for purposes of the First Amendment and the extent to which that power could lawfully be modified raise interesting and important questions. Thomas argues that some digital platforms are sufficiently akin to common carriers like telephone companies. A traditional telephone company laid physical wires to create a network connecting people, Thomas writes. Digital platforms lay information infrastructure that can be controlled in much the same way. Thomas argues that while private companies aren't subject to the First Amendment, common carriers are unique to other private businesses in that they do not have the right to exclude. Thomas suggests that large tech platforms with substantial market power should be bound by the same restrictions. If the analogy between common carriers and digital platforms is correct, then an answer may arise for dissatisfied platform users who would appreciate not being blocked. Laws that restrict the platform's right to exclude, Thomas writes. Such a restriction would subsequently curb tech giants' ability to moderate content, a proposal that both tech giants and those on the left who want to see more aggressive content moderation online would almost certainly reject. Yeah, because they want to control the narrative. That's really what it is. It's them controlling the narrative, right? It's the people on the left. It's the people in these big tech companies that are controlling what people are seeing. I mean, I got a strike for quoting the CEO of Facebook, right? I wasn't saying anything myself, but I'm the one who got hit. I'm not going to repeat what I said, but it was a narrative that they're trying to adhere to. That's the whole reason the Project Veritas thing came out. That's what I was reporting on. Thomas goes on to describe the sheer scope of Facebook and Google's market power, citing Facebook's roughly 3 billion users and Google's 90% market share in search. It changes nothing that these platforms are not the sole means for distributing speech or information. A person could always choose to avoid the toll bridge or train and instead swim the Charles River or hike the Oregon Trail, Thomas writes. But in assessing whether a company exercises substantial market power, what matters is whether the alternatives are comparable. For many of today's digital platforms, nothing is. It's true. Okay, I use DuckDuckGo. I don't know what you use. I don't use Google. I use DuckDuckGo. I still say Google it. I still hear Google it, and I know what that means. Look it up online. It's like a Band-Aid. Band-Aids aren't, they're adhesive bandages. Band-Aid is a brand. Google is now the word that's synonymous with searching something online. I don't use Google, but is it comparable? Well, what's comparable to Facebook? MySpace? I can't think of anything else. Twitter, what's comparable to Twitter? Okay, Gab, well, they got rid of it. Parler, well, they got rid of it, and Gab fought back and now built its own infrastructure. Parler, so they got rid of Parler. I mean, the CEO of Facebook, or of Twitter, was basically like, haha, we got rid of Parler, flaunting it. Thomas states that in order for an account like @RealDonaldTrump to be truly classified as government-controlled, the power of a platform to unilaterally remove a government account would have to be reduced. Agreed. Thomas acknowledges that it would be up to a legislator to impose such a restriction, and that the Twitter blocking case before the court didn't offer an opportunity to grapple with those questions. But, he writes, we will soon have no choice but to address how our legal doctrines apply to higher concentrated, privately owned information infrastructures such as digital platforms. He's absolutely right. Back when I was on Tim's show, we talked about Section 230 and how it needs to be reformed, not repealed. A lot of people are like, repeal it. It needs to be reformed. It needs to be changed and altered so that they don't get to just use it. Last 2 or 3 weeks ago, Eliza was posting about how Twitter, there's so much of this stuff that is on Twitter, but they're citing Section 230. Well, we're not liable, and it's the narrative. They can get rid of whoever they want, but when they don't care to get rid of things, Section 230. You can't sue us. It's not our problem. It's not our fault. Yes, it is. Because they're choosing who's on their platform. They're proving it time and time again. Well, check this out. Following Clarence Thomas's lead, Ohio Attorney General files lawsuit to classify Google as common carrier or public utility. So it's actually may start happening. Okay? It's not set in stone yet, but it's laying the groundwork. It's Clarence Thomas, I salute you, sir, because you flicked over the first domino. You stood strong, and you're like, no, these people need to be held accountable. We need to rework 230. Okay, they are clearly making decisions. They are clearly publishers. They're getting to decide who is on their platform or not. They banned a sitting president because they didn't like what he was saying. Well, they already ruled that that president couldn't ban someone from his own account because it was a forum, a public forum. So they already declared that in some sense, some accounts on Twitter are public forums, and it was his account that is considered a public forum. And then they banned him. Ohio Attorney General Dave Yost has asked the court to legally declare that Google is a public utility in a lawsuit filed against the big tech giant. According to Yost, Google should be viewed in the same way as electricity, water, and gas providers, arguing that Google hurts its rivals by prioritizing its own products and services in search results, displaying them above those of competitors. And that's just one. Now, the rest of that article basically reiterates all of the things that I already read to you from Clarence Thomas himself. So, but the point remains. We need to reevaluate Section 230. We need to be protected online. We have to. The internet is it's new. Think about how long we've had the internet. 30 years max, okay? It's okay, how long of this in the span of human life is 30 years? Nothing. It's a little speck of dust. 30 years is nothing. I'm almost 40, so it's like a good portion of my life. So for my perception, 30 years is a lot. But I don't know. Yeah, it's crazy. So I'm really looking forward to this because this is important. This is really, really incredible for the future of our rights being upheld on the internet. So thank you, Clarence Thomas, and thank you, Attorney General Dave Yost, because this is really important.